You're watching Bill on Bankruptcy. I'm Lee Pacquiao here, of course, with Bloomberg News bankruptcy columnist Bill Rochelle. We're going to be taking you through a whole slew of developments in the bankruptcy space. If you'd like to know any more information on anything we discuss, be sure to go read his column on BloombergLaw.com. Our first item could be under the subheading, Never Make a Promise You Can't Keep.
Well, that's exactly right. NewPage, the very large paper manufacturer, kept saying in its Chapter 11 case that there was no theory on God's earth where unsecured creditors could come out with a farthing. Well, unsecured creditors threatened a lawsuit. There was a mediation, and guess what? A settlement under which unsecured creditors get 6 cents on the dollar for their claims. I guess this is just another reason why you can't believe what a lawyer says, even if a lawyer says it in writing.
Our second item, for me at least, is the surprise of the week. What happened?
Dewey, the big settlement, $71.5 million settlement, where 444 of Dewey's former partners agreed to chip in that much money to relieve themselves of the prospect of being sued. A bunch of the partners opposed, and many of them wanted to have an examiner appointed before there was any approval of the settlement. Bankruptcy Judge Glenn didn't like it worth a darn, that is to say, the idea of slowing down the settlement. He approved it in a 26-page opinion, and it looks like it's a done deal, unless, of course, there is a successful appeal.
Bill, when I saw the next item we're going to go through, I muttered under my breath, "You should live so long." Take it away.
Well, we're, of course, talking about Lehman. We are after the 4th anniversary of the Lehman filing. And on the brokerage half of Lehman, they blew out about $90 billion just shortly after the bankruptcy filing. This is basically customer securities that they could deliver out. But then they were stuck with a bunch of disputed claims and whatnot, and a bunch of money they couldn't collect on account of the fact that there were huge claims by affiliates. They have just brought in settlements with the affiliates in Switzerland, in the UK, and of course with the parent, Lehman Brothers, in Chapter 11. This will, sometime in the first quarter of 2013, allow Jim Giddens, the trustee for the Lehman broker, to make a distribution which, thank goodness, after all this time, will pay customers in full.
And Bill, we're saying this next case is an episode that could be entitled Jack the Giant Killer. Who's Jack and who's the giant in this one?
Well, in this one, Jack is the Madoff trustee, and the giant is Attorney General Schneiderman from New York. Jack, the Madoff trustee, is trying to stop the Attorney General from carrying out a $410 million settlement with somebody the Attorney General believes defrauded indirect Madoff customers. In addition, the Madoff trustee is trying to do the same thing with respect to Attorney General Harris in California. This is an issue to be decided by the District Judge Jed Rakoff, although I believe that the Madoff trustee has done a fine job in shepherding the case. This time he is up against a mighty formidable adversary in Schneiderman, and it wouldn't be surprise at all to me if Schneiderman didn't come out on top on this one, because he's trying to exercise police and regulatory powers, which presumably are not enjoined by bankruptcy.
And I know this is a show, of course, on bankruptcy, but this next story touches on the political realm. What happened?
Bain Capital.
Oh, okay.
Yes, sir, Bob. I had to somehow get the election into it. Bain Capital had one of its portfolio companies in Chapter 11. Of course, if anybody has been asleep for the last 10 years, you might know that the Republican nominee is a former leader of Bain Capital. In any event, they had a company called Contech Holdings, and they went through Chapter 11 like a hot knife through butter. About 5 weeks, no kidding, 5 weeks, start to finish. If Mr. Romney, Governor Romney, is as good at being a president as Bain is at getting companies through Chapter 11, then he will make a mighty fine president.
Next up is our want ad section. What companies are for sale this time?
Oh, I guess you could say we start off with a bite-sized company because it's a pizza chain in Boston called Upper Crust Pizza. If you like this kind of a retailing business, that's for you. Next is agriculture. How about that? First off, we have a company in Pennsylvania called Penfield. It makes animal feed. And really sort of in an allied business, we have Zacky's out in California, which is a poultry producer.
A big one.
oh boy, 2.5 million birds they feed any day of the week. Both of these companies, by the way, are being smushed because of the high price of corn and other feeds. In other words, what they get for their product is not elastic, but the price they have to pay for the feed is very elastic, and they're getting crushed. Oh, by the way, same with a bunch of dairy farmers we have reported about.
Yeah, I was wondering what's happening in the chicken farming space. It seems like we've reported on an awful lot of chicken farms in the last year or so.
It's not a good time to be a farmer.
Sure, sure. And Bill, our last segment, of course, is advance sheets. What important court rulings have come out recently?
Well, first thing is, if you're in the Second Circuit, the New York area, forget everything you know about what is an interlocutory or final order, because they came down with a decision in the Lehman case which says technicalities are out the window. If you want to know what is interlocutory or final, you must look at the practicalities of the case, not the technicalities. Second, we have a decision from the Fifth Circuit, from a district judge, by the way. Folks down in the way of Texas are very much bothered always by what's called the United Operating Decision from the Fifth Circuit, which says that you have to lay out in detail all lawsuits you intend to bring after bankruptcy. I'm beginning to think that United Operating now is all but a dead letter. This latest case is called Tepper versus Keith from the Northern District of Texas. And finally, let's end with Vitro. I had the great pleasure of going to New Orleans to watch the oral argument in this case. Time doesn't allow to tell us what it's all about in this space. But nonetheless, when the decision comes down, I dare say it will be the single most important cross-border, multinational bankruptcy decision in the history of the United States. It will tell us whether a company can go off to another country, accomplish something in bankruptcy it could never pull off in the U.S.
All right, Bill, thanks for that. That's what we have for this week. If you'd like to learn more about the cases and issues we just discussed, be sure to go find Bill's column. It's available on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Lee Pacquiao. See you next week.